A federal judge in Washington, D.C. examines a brand new $100,000 visa fee and rules that it is perfectly legal. 6 months later, a different federal judge in Boston looks at the exact same fee and rules that it is entirely unconstitutional. This chart compares historical visa costs to the new mandate. For years, employers paid roughly $5,000 to sponsor a highly skilled foreign worker. Then, a presidential proclamation spiked that cost to $100,000. That is a 1,900% increase implemented immediately. The administration argued this surcharge would protect domestic jobs by making it too expensive to hire foreign labor. In practice, the high cost meant that by early 2026, many hospitals, universities, and small businesses simply stopped filing H-1B petitions altogether. This leaves the American legal system at a standstill, with two valid opposing orders governing the same federal policy at the same time. The entities fighting this in court are not Silicon Valley technology giants. The plaintiffs are a coalition of 20 state governments. State officials sued because the American medical system relies heavily on foreign-born talent to function. 28% of all practicing physicians in the United States were born in another country, and many of them use this exact visa program. The institutions getting priced out of specialized hires are small-town infrastructures. Rural hospitals that need cardiologists and public school systems struggling to find special education teachers do not have the budget to pay a six-figure premium for a single hire. A multinational technology corporation can absorb a $100,000 penalty. A regional hospital in Montana cannot. The fee effectively cuts off Middle America from essential specialized talent. To understand how the courts split, we have to look at the legal logic. In December 2025, Judge Beryl Howell in Washington, D.C. validated the fee. This chart visualizes a statutory grant of authority. Congress writes the laws, but delegates broad power to the president to restrict immigration. Judge Howell reasoned that a barrier to protect domestic wages fits neatly within those powers. Under this interpretation, the president is operating entirely within the rules, using established legal tools to defend the American labor market. 6 months later, Judge Leo Sorokin in Boston analyzed the exact same policy and applied a completely different constitutional lens. He looked at Article 1, Section 8 of the U.S. Constitution, the taxing clause. Sorokin determined that charging $100,000 is so exorbitant that it stops being a standard administrative fee for processing paperwork and crosses the line into a revenue-extracting tax. The Constitution is strictly clear on this point. Only the legislative branch, Congress, has the authority to levy taxes on the public or on corporations. The president cannot do it unilaterally. This creates the ultimate binary question. Is this policy a legally authorized immigration rule or an illegal executive tax? Because the Boston ruling vacated the policy effective immediately, the fee is gone today. Employers can currently file visa petitions at the normal rate of roughly $5,000. But employers are operating in a precarious legal limbo. The administration is appealing, and an appellate court could issue a stay at any moment, reinstating the fee and instantly freezing the hiring market again while the case is argued. With two conflicting circuit court decisions and a third lawsuit currently pending in San Francisco, there is only one way this ends. The United States Supreme Court will have to intervene to settle the discrepancy. The final ruling will establish whether a president can use proclamations to bypass the congressional power of the purse and unilaterally levy financial charges. The Supreme Court's decision will determine the future cost of entry for the doctors, teachers, and specialists who underpin the American workforce.